All right, welcome to the Creative Finance Collective. This is your opportunity to ask questions about all things related to creative financing, creative finance. And Sean and I are here, and we're going to take questions for as long as we get them, or until they run out. And if they continue going, we get lots of questions. We'll go up to an hour. So if you're just now joining us, and if you're not on the YouTube platform, make sure to check us out on YouTube. You can go to the barcode at the top of the screen, scan that with your phone. That'll take you right to our YouTube channel, kind of the best place to monitor and watch our content that we provide at the NREM podcast. Sean, we already got a question. So you might have seen it, but I'll go ahead and read it and we can just kind of address it as we go. So, what are my options as the buyer if the lender calls the loan due after the sale? I think there's maybe it's missing a little context, but I think in the sense of creative finance, after the sale, the lender finds out about it for one reason or another, and they've called the loan due or sent some letter to that effect. What does that look like, and what are the options?
So, not all due on sale clauses are the same. They're similar, but there are some subtle differences that you have to be aware of. But the one thing that all due on sale clauses are going to have, or that I've seen ever will have, is a provision that basically says that the lender will send out a letter or notice that there's been a transaction falling within the due on sale clause, and then you have 30 days to pay.
They habla español.
Now,
Hey, Scott, can you hear us? Not sure Scott can hear us. Sorry. Well,
so within that letter, though, they don't have to. Legally, all they have to do is send the letter and say, hey, there's been this event and you have to pay us in full. That's their legal that's what the due on sale clause states, and that's all they have to do, and they can demand full payment. However, the due on sale clause letters that I've seen basically gives the seller three options. It says, number one, pay the loan in full in 30 days. Number two, put title back in your name. Or number three, if it's been transferred to an LLC, show us proof that you're the 100% owner of the LLC. And if you do one of those two things, it satisfies the due on sale. Now, if you have a cooperative seller, then you could, at least here in Arizona, Texas may be a different story, but if here in Arizona and you have a cooperative seller, you could actually go and deed the property back to them and do another type of transaction structure, whether that be an agreement for sale or at least with an option to purchase containing the same, substantive terms that you previously had under your original wrap. If you have an uncooperative seller or you just don't want to do that as the buyer, then you are left with three options that unilaterally you can choose what to do. And so the first is to simply sell the property and pay off the loan. The second is to refinance and pay off the loan. Or the third is, if you have the resources and you want to do it, figure out how and pay off the loan without another lender involved. But those are basically your three options to avoid a foreclosure or the lender filing a lawsuit to take the property back via judicial foreclosure. So that's it.
Yeah. Well said. Let me see. I saw that we had Scott Horne joining us. Scott, can you hear us? Oh, he popped out. He's going to try popping back in. All right. So we had we got another question, but there was a follow-up to the same person who asked the initial question. So I'll stick with that just initially. But they asked, how much time will I have once the letter calls the loan due?
So you're going to have at a minimum 30 days, because that's what every due on sale clause says, is that they're going to give you a 30-day notice. Now, what happens after those 30 days is really dependent upon the lender. If you have a lender that's Johnny on the spot, they might file a lawsuit, and you still have the ability to sell the property, except you're going to get stuck with a loan payoff that has a bunch of attorney's fees and costs and expenses related to that filing of the lawsuit. But if they're not Johnny on the spot, then you could have another few weeks after that to pay off the loan or do something. But in order for you to actually work with the seller and resolve the issue, you're going to have 30 days from the date that the lender sends that letter, if you're going to try to do a workout with the seller and meet the lender's requirements. But otherwise, if you're going to do some type of self-help, you have a minimum 30 days plus however long the lender drags its feet until it actually files a lawsuit. And then even after it files a lawsuit, you can do something. It's just going to cost you more. And frankly, if they do a judicial foreclosure, which normally when they do invoke the due on sale clause in this case, they're going to do a judicial foreclosure. Then even after a judgment's entered and the property is sold at the sheriff's sale, you have another 6 months redemption right. But once again, you're going to pay a bunch of fees and costs and et cetera. It's going to be a lot more expensive. But you bottom line is you have probably a good 6 months to a year minimum to do something. But the longer you wait, the more it's going to cost you in the process.
Yeah. Scott, I see you popped on. Can you hear us okay?
Yeah. If it's not one thing, it's something else, isn't it? One day the audio, this time the camera it was working, then it just stopped. So I went to the phone.
Yeah. Well,
what are y'all talking about, by the way?
Well, we got go ahead, Sean.
The question was, what are the options if you acquire a property subject to the existing loan, presumably by warranty deed? What are your options if the lender calls the loan due? And so I kind of went through what those options would be. They may be a little different in Texas as far as a seller workout, but I think the options are the same if there is no seller workout, which is pay it, sell the property, pay it off, refinance, pay it off, or come forward with, if you have the cash, and pay it off yourself without financing.
Oh,
but
guys, I have got to come to Arizona and I'm going to bring a 2x4 and whack it between your ears like a horse, There are other creative mechanisms that we can always talk about that work.
Like what?
Oh, it just takes a lot of fancy footwork. I always, out in the environment, the investor environment, guys, and I know y'all hear this as well as I do. I tell investors that you always hear about a land trust, right? Everybody thinks a land trust is some magic pill of some type, and it's not, but they think it is, and that's great. But I don't have an objection to using a land trust if somebody is buying a home subject to live in it as their residence, to use it as a fix and flip, or a rental property of any type. I think it's fine. And maybe that even helps to disguise the deal from the lender a little bit, but it's not a guarantee by any means.
Well, let me interrupt you right there. So the three things that I laid out were the unilateral actions that a buyer can do, meaning the land trust at that point would take seller cooperation. And I admit there's a lot more you can do if you have seller cooperation, like a land trust.
But this is all in the beginning, though. So
in the beginning. Well, yeah, but they're asking what happens if you didn't do that, or the lender found out about the little land trust scheme and called the loan due.
I have it there. So you got
it. Go ahead.
So if someone, you always want the investor to think past their nose. And unfortunately, sometimes they don't. They don't think about that what if factor. So one thing I want an investor to always be thinking about is, before you buy a property, what is your back end disposition? Now, if your back end part of the deal is going to be a wraparound mortgage, I don't want to close it into a land trust. unless you want to do a whole lot of extra paperwork up front that most investors just don't want to do, because all of us investors, and that's me included, are cheap. Now, I'm saying that for my partner, Susan, who's listening, because she's nodding her head right now, by the way, because she knows I'm cheap. But along the way, I like to buy a deal. In fact, I buy all my houses into an LLC, and I do a wrap out of my LLC. So I do that because I know that the odds of the due on sale being called are usually very slim. Great. So what if it does happen? Well, in that case, I already have my POA set up with my seller, where I can handle anything I need to handle with this property. And so either with or without the lender participation, I will transfer the property back to the original seller, provide a copy of that deed to the lender, and then I'll reconvey the property back into a land trust. Now, at that stage of the game, I usually stop and let things season for a bit out there. Now, I'll make certain that that land trust, of course, is conveyed back to the investor. So the trust owns the property and the investor owns the trust. It's just that they're not going to record those documents at this point in time. They have the option to record them down the road if they so choose. Now, if this was a wraparound mortgage, that was a scenario, I do a lot of other paperwork between the land trust elevated here and the investor's LLC here to reinsert that LLC back into the trust or into the equation. And then I will eventually assign my land trust to the back end buyer. Now that gets real messy. There's a lot of moving parts. You got to be able to explain things to the back end buyer properly. The seller usually doesn't care. They're out of the picture one way or the other. They're just happy to be gone and have their loan current. And it's just, unfortunately, it's a lot of maneuvering. And so I don't like to do things of that nature unless it really happens. And guys, in my 30 years of doing this, and a gazillion closings that we have done, I've dealt with due on sale today a total of 11 times. So I just don't see it being a major issue that I don't worry about unless I have to worry about it. And sometimes it happens, and when it does, okay, we'll cross that bridge. But there's usually some mechanisms that we can play with, and the system I kind of described, I didn't go into too much detail because I just don't want to get off track on all the legalese and whatnot that we go through. But I'll tell you that mechanism has worked all those times. But as I tell every investor, it may have worked those past 10 or 11 times, but there is zero guarantee that it's going to work the next time. It's just the nature of the beast. The only guarantee that you have is what you espoused, Sean, which was refinance the loan, pay off the loan, or do something else with it. That's the only guaranteed mechanism there is. But I have found some fancy footwork behind the scenes that has allowed us to get things accomplished that over the years has seemed to work okay. But man, in anything we do as lawyers, we know that there's not a guarantee that it's not a magic pill, in other words.
Yeah. If you're just now joining us, as the Creative Finance Collective, we're taking questions throughout the hour. We've got Scott Horne out of Texas. Sean and myself are from Arizona, and we'll do our best to answer any creative finance, real estate related questions. Also, you'll note that there is a barcode at the top of the screen that takes you to our YouTube page. If you're not watching on YouTube, that's the best way to follow us. So go there, subscribe. We'd appreciate that. We've got a question from a Facebook user, not a creative finance specific question, but a question nonetheless, and I'll go ahead and read it. I loaned money to someone, but I did not get a signed agreement. Now he is not paying anything. What can I do? Well, that's a story as old as time.
Yeah, I mean, and that the problem is, why didn't you get an agreement? Um, Basically, there are some safeguards in the law to guard against that, but that was the biggest mistake right there. I mean, an ounce of prevention as opposed to a pound of cure, right? But
Guys,
in Arizona, you have like unjust enrichment and quantum merit, and depending on the nature of the agreement, you can establish an oral agreement. You can establish unjust enrichment or quantum merit claims without a written agreement. But at the end of the day, depending on the nature of the loan, you may be out if it falls within the statute of fraud. So bottom line is, you probably are going to have to file a lawsuit, because that's the only way to obtain any type of significant right to, access their assets and obtain payment. Scott, what were you going to say?
I just want to know who took the stupid pill all the time. I hear that more often than you don't even want to realize. And you go, you did what? Or,
Well, sometimes we trust somebody that we're hoping we could still live in a world where we shook hands.
well, what did our good friend Mr. Reagan say?
Are we talking about President Reagan?
Yes.
Oh.
Trust but verify. Friends are friends, business is business. Get it in writing, always, always. And I get what gets me, guys, is this. And I can give you all so many examples over the last 5, 6, 7 years, probably, where everybody, again, it's the greed factor, okay? It's the bottom line. Everybody wants to lend money. They want to be part of a deal. They want to be part of a real estate deal, but they're scared to do things themselves. They want to make more money than they probably should make, and things of that nature. They become opportunists. But they'll do this thing called gap funding. Have y'all heard of gap funding there?
Mm-hmm.
And all that is where an investor borrows money, let's say from a hard money lender or a bank, but they need that extra 5%, 10%, 15%, whatever it might be, to get the deal finalized that they couldn't borrow for some reason. And so they go to these private lenders who will lend them money. And of course, we as the lawyers would go, okay, if you want to do it, but do it in a second lien position, right? Record a deed of trust on the property. And what they do is they don't do that. They let these investors talk them into a JV agreement. And so they just give money to the JV that, of course, goes to the JV partner investor. That money goes poof, it's gone. They find out that, and even sometimes they might get a promissory note signed with the JV agreement, but not with the investor. And of course, the other partner is usually an LLC of some type. It's never the individual. So there's no liability, there are no personal guarantees. There's no nothing. They just want to make money, loan the deal real fast, charge XYZ, be part of the deal. And these investors just will screw you blind. There was a guy here in Dallas. This is, probably been, 3-4 years ago now. And so Susan, forgive me for bringing up the name Fortune Builders, but he got to be a big deal at Fortune Builders, which is a big training group. I'm assuming you guys have heard of Fortune Builders before. And got to go on stage, talk his game, and started having a lot of people contact him who wanted to lend him money. And this guy was just major self-dealing. He'd buy a property, his wife would get a commission. He'd do the rehab on the property, he was getting a construction fee. They'd go to stage the property, the wife got paid again. They go to sell the property, the wife gets paid again. There's another fee out there, this and that. But these investors kept lending and just giving money to this guy in a JV agreement with these exorbitant interest rates. And I know we've had the usury talk before, but 20%, 30%, 40% returns. And of course, you scratch your head, and I get that right time, right place. If you're putting work in a deal, you can get those kind of returns. But just lending money, not usually. Every single investor who invested with this guy on properties, not only first off, the guy got foreclosed on by every hard money lender, and every one of the investors lost money. I lost count somewhere between $500,000 and $600,000 just out the door. But it's kind of like not one person, not one of 15 different investors probably secured themselves with a deed of trust. And they weren't able to go back, foreclose the property, take over that first lien hard money loan, resurrect it, and recoup their dollars. And they were left filing a lawsuit against someone who had no money, and they're just going to go piss in the wind because the guy had no money, or he had it sufficiently hidden. You're not going to get to it anymore. But it seems to be an age-old story that happens all the time. And the best advice is, I think, Sean, you said it earlier, is that ounce of cure up front. Take 5 minutes, call Andy, call Sean, call Scott, call somebody, and do it the right way to CYA.
Yeah, and just to add a little more context, the Facebook user mentioned they have proof in a text. How much does it cost to file a lawsuit? He sent me a document, but I just saw it was never signed by him. So, a document was prepared. Somebody thought that they were operating under a document. They weren't careful about getting the signatures. They can send out the money, and lo and behold, they didn't get paid. Now, one thing I would add to what Sean said is, unless you have, and you mentioned this, Scott, too, even if you have the written contract, unless you have some sort of collateral that you're secured to, your option is still to file a lawsuit. There's no like remedy of repossession or grabbing assets, whether it be real estate or personal property, just because you have a deal. There's separate agreements that allow for that. So in either case, you're in a position of filing a lawsuit, and it's just going to depend on what kind of theory, depending on what state you're in. Every state treats oral contracts differently. Every state treats, like Sean said, unjust enrichment type claims. I think it's safe to say, you guys tell me if you think differently. You could tell me what it might look like in Texas, Scott, or even Wisconsin, Sean. But I mean, usually what you could expect in just to file a lawsuit, out of the gate, be prepared to spend anywhere from $1,500 to $2,500, or $1,500 maybe to $5,000, depending on how complex the lawsuit is. And that's just to get it on file. That's just to begin the process, right?
Right. Well, let me jump in, Andy, and because Scott brought it up, and I'm going to go on a little bit of a rant here about JV agreements, because they are being used all wrong. And in fact, on our show, the intro to our In-Rim podcast, we have a statement from, Paul Vincent, where he's talking about the, complying with securities law. And he goes, I'm just going to JV it, and he goes, whatever the hell that's supposed to mean. Right. And so, these investors are running around engaging in unlawful activities and then trying to whitewash it through a JV agreement. And that's not how a JV agreement is supposed to be used. A JV agreement, it can be used and is a good instrument in certain circumstances, but you have to do it right. So a good example would be, Scott and I agree that we want to go and invest in a property, and we don't want to, maybe we don't have time or otherwise, and we don't want to go through the rigmarole of being members of an LLC, or we just need to close on it. And so what do? We say, okay, Scott, I'm going to be a 50% owner. You're going to be a 50% owner. We're both going to go on title, but we're going to document our relationship with this property and with each other by a JV agreement. And then the JV agreement explains how we are going to treat this property and operate as basically partners in this property. We're both going to be on title. It's not designed for Scott to go on title and me to be somewhere in the background, with the JV agreement saying I have some interest in the property. Now, I've done that. I've done that where there's been somebody who for whatever reason, they're not going to go on title. Maybe they came late to the game, but they're going to partner up with somebody who's already on title. Well, you know what we do then, and you can do this in Arizona, and I'm assuming Texas is the same way. I put together the JV agreement, and I put in the JV agreement. This is going to be secured by a deed of trust on the property. You will not sell this property until you pay me off because we have this deed of trust. And oh, by the way, if you breach the JV agreement, I have the ability to foreclose. In that case, it was like a 50% interest. I have ability to foreclose and take out and get my 50% interest out of this property if you don't comply with the JV agreement. So, in Arizona, mortgages and deeds of trust don't have to just secure promissory notes. They can secure other agreements. I've secured judgments. I've secured settlement agreements. I've secured JV agreements with deeds of trust and mortgages, and you can do that. But a JV agreement isn't supposed to be this thing where you say, oh, well, I can avoid securities laws. No,
avoid securities. I can
engage. I can do other activities. I can act as a real estate licensee, or I can act as an attorney, or I can act as this and that because I have a JV agreement. No, it doesn't work that way. You can't do that. It's designed to basically document a partnership between two parties, and it should be properly secured either by an ownership in the property itself as consistent with the JV agreement, or secured by a deed of trust or mortgage against the property that you're entering into this type of, profit sharing or partnership or other arrangement on. So I just over and over see these JV agreements being used completely improper. And they say, well, it's a JV agreement. Well, no, you can call a document whatever you want to call it. It's the substance of the document that defines what it is. It's not the title, it's the substance of the document. So, if you have things in there that are, constitute securities or constitute, compensation for acting as a real estate licensee, I don't care that you call it a JV agreement. It is what the substance of the document is, and that's the way the courts, law enforcement, judicial bodies, administrative agencies, they're all going to interpret it that way, not just because you put a heading JV agreement. So I'm off my soapbox, but yes, I've been seeing too much of that with JV agreements.
Well said. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour or until we stop receiving questions. You'll note that there's a barcode at the top of the screen that takes you to our YouTube channel. So if you're watching from Facebook or Twitter or one of the other platforms, this takes you to our YouTube channel, which is really the best place to follow our content and engage with our content. So go there and you can scan that, and that'll take you right there. We have another question. Can I purchase a property subto from an estate that is in probate? I don't think we've had this question in a while. What do you guys think?
Well, I was just dealing with, so anything can happen, but can you buy it from the estate? I think the executor of the estate, so long as it's in the best interest of the estate, can sell the property in that format. Now, if there's an executor involved, the question is going to be, is it an independent executor or is it going to be dependent where you need court permission to sell it? But if an independent executor feels that it's in the best interest of the estate, the answer is yes, because there's not a liability issue out there, because the person who's liable in the debt is no longer with us. Now, normally, though, you don't run into that scenario. You run into the scenario where you have heirs and there is no probate filed. And so you've got to get your heirship affidavits or the mechanism to get title into the heirs' names. And then you let the heirs sell the property in that format. And of course, again, heirs don't care. They don't have any liability. It makes the transaction so much easier. Sometimes they may want to carry back a deed of trust. The one I was just working on yesterday, they just wanted out of the deal and walk away. And they just wanted to transfer a deed only to the buyer, and they didn't care about a deed of trust or if anything happened down the road. So I think that the answer from my end is, yeah, you can do it. Sean, your thoughts?
Yeah, I agree. Sometimes it takes, especially if a probate attorney is involved, it takes a little bit of education of, what this means and what it looks like. There's some really good probate attorneys and there's some not so good. And probate's one of those areas. So I had a friend that was he's a surgeon, but not only, well, I shouldn't say surgeon, he's like OBGYN, but he's for high risk, which means not only does he have to understand the OBGYN stuff, but he has to understand, heart issues and cancer and all these other medical areas to be good at what he does. And that's kind of like a probate attorney or a bankruptcy attorney. And there's a few areas of the practice of law that you have to understand probate, but you also have to understand real estate and these other areas, business and these other areas to properly and effectively administer a probate estate. You have to be very knowledgeable, if not an expert, in all these other areas. So there's some probate attorneys that, are just out of law school and never done anything but probate and don't understand, okay, well, what would that mean if there was a promissory note or an obligation to pay, to the heirs, what happens if they don't pay? What does it look like? How do I make sure that the promissory note and payments get to them? And there's other attorneys who have done real estate and otherwise, and also do probate, which would understand, if there's anything above the existing loan that's going to be paid, a portion that's seller financed by the estate, well, then that's easy, right? We just assign a percentage of the note to each beneficiary. We give instructions to the servicing agent that, hey, every month you cut, a 1/3 check to this person, a 1/3 check to this person, a 1/3 check. And then, these beneficiaries have this residual income coming in, and potentially could get more for the property than they otherwise would just selling it for cash, and getting, a lump sum. So, it can be done. It's very doable. It's something that's wise, I think, from an estate's perspective. But sometimes it's a matter of educating the attorney, and the attorney's going to say no if they don't really understand the real estate aspects and what it would look like. So that would be my follow-up.
Yeah, and I think that following up on what Scott said, I love it from the credit side of things because with a deceased, a big risk to the subto for the seller is the credit risk. That and like Scott said, you just don't have that. So that takes one hurdle out of the equation to make it potentially a good deal. And no doubt that if there's been an appointed personal representative or executor, depending on your state, they have the power to sell. It's the question is, is it going to be in the best interest of the beneficiaries and do they sell?
Well, Sean, you made a comment about, probate attorney getting involved. I think the issue is any other attorney getting involved because the great majority of the lawyers don't understand these deals. This is a very niche practice, I think, out in the marketplace, it seems like, along the way. But, you can set a deal up. You can work it out of a probate in so many ways. As you said, Andy, it limits the liability to the heirs. Obviously, they can elect to carry it back, not carry it back. I think the issue that the investor has to deal with is ensure that there is either letters testamentary or an heirship affidavit that is delivered to the lender, that they get a proper power of attorney with the proper heir or executor so they can navigate that loan down the road long term and think for those kind of things and go from there. And just to make another point about probate out there in the subto world, so many people think that just because somebody passes away and has a mortgage, that you have to call the mortgage company and tell them everything in the book. You don't have to tell them squat. Just make your payments and move on, right? But these people, they want to call and they want to talk to them, want to tell everybody everything. It's like, stop. And then they turn around. It just wears you out. It's like people in this business, they want to do a subto, but they order a payoff on a mortgage. Well, why are you ordering a payoff if you're intending to buy the property subject to and just reinstate it? It's just like, all you're doing is raising red flags with the mortgage company when you do these kind of things along the way. And over here in my offices, we have piles of hair that we pull out, with things like this that pop up all the time.
All right, we have another question. We should move on because what little hair left Scott has left is precious. This one might be for you, Sean. Maybe they've been listening to your legal update. Is the buyer on an agreement for sale entitled to homestead law protection? And I wonder if they mean by this, given the fact that on an agreement for sale, the buyer isn't on the bare naked legal title, right, on the deed, right? They've got a equitable interest. Does that change in your estimation we'll start with Arizona, how its homestead protection law would still apply?
So the answer is in Arizona, yes, they would be protected if they meet the other requirements of the homestead. So basically, the homestead protects a person's interest in real property in one compact body on which sits a dwelling. Okay. Interest in. So it doesn't say their fee simple interest in, their title interest in, it's their interest in. And an agreement for sale creates an interest in the real estate. Now, it may not be a full fee title interest, but that's not what the statute requires. It's just the interest. Now, once again, to qualify for the homestead, it's one property within the state. Like, you can't have multiple homesteads. It's one property, and it has to be your primary residence. So those are the requirements. So if an LLC owns it, no, there is no homestead. An LLC doesn't get a homestead. It has to be owned by an individual or a trust for which the grantors are individuals, and the grantors are the ones claiming. The grantors and beneficiaries are the individuals, and they're the ones whose social security number is being done to file taxes on behalf of the trust. And in that case, yeah, you're entitled to the homestead if all those other things are correct. But yes, an agreement for sale does allow you to qualify for the homestead.
I know your agreements for sale are kind of unique, or they're treated differently in Texas. How would Texas apply to that?
Well, first off, so we call them contract for deeds. You all call them agreement for sale. Mm-hmm. And in Texas, at least, you're not going to be putting an owner occupant in a property from a homestead perspective because it's barred.
Oh, we lost him.
Yeah, I think he was going to say it's barred. I don't think you can sell to an owner occupant in Texas on an agreement for sale, but maybe he can clarify when he jumps back.
Yeah. Another question. Are there ways to contractually penalize a seller in a subto deal for notifying the lender of the sale?
Well, that may or may not work. It depends on how the transaction is structured, right? Because, anytime you're going to penalize somebody, you have to have some asset or leverage for the penalty, right? Otherwise, it's just as good as the paper it's written on.
Right.
So if the financing, if the seller's carrying back any of the financing, let's say 200 is owed and the seller's going to carry back 100,000 for a total loan amount of 300,000. And so 100,000 of that, or the payment on 100,000 is going to the seller, then you could have and put in theory, some, liquidated damage or otherwise that gets subtracted from the amounts owed to that seller under that additional, equity payment or the monthly payments that are going to be made to the seller over and above the payments to be made on the existing loan. But absent that, you could say, oh, seller, you owe me $500,000 if you notify the lender and try to, interfere with my rights under the contract. But are you going to really get 500 from the seller? Like, it's pointless to do something like that. But assuming you have an agreement with the seller whereby the seller is owed something from you, then you could put in some type of penalty clause that would allow you to offset your damages or have some form of liquidated damages that you use to offset the amount that you would owe the seller over and above or independent from the amounts that you owe on the existing or have to pay on the existing loan.
Scott, before you fell off, I know you were in the middle of making a point. Did you want to finish that with regard to contract for deeds? Oh, no, we're not getting any sound from you, Scott. No, still no sound. Scott's, yeah, still not getting any sound. Try logging back in. Sean, we have another question. Can you please suggest a subto friendly attorney in Arkansas?
Not off the top of my head. I don't know that I have a referral in Arkansas. Let me look. Arkansas is close to Texas. Maybe Scott will have somebody.
Scott might have somebody. It's also not too far. Yeah, I guess it would be closest to Texas.
Yeah, it is. It's right. I mean, in fact, about a month and a half ago, I drove through Texas and directly into Arkansas from Texas. And
Scott, can you hear us?
right before the big storm came through there.
I can hear you fine. Can you hear me?
Yeah, we can hear you fine. We just got a request, somebody looking for a sub-2 attorney in Arkansas, and that's closer to your neck of the woods. Do you know anybody out there?
No, but we do closings in Arkansas, so we could assist them with that if they need that.
Hey,
Okay.
see, there we
We
go.
just can't
That
provide
might
them
work.
legal advice per se, but we can certainly help them with the closing. So, hey, Andy, if I can just interrupt for a moment, and I change locations. Maybe my chair and my desk is just a dead spot. Who knows? Whew. But, so first off, a homestead with a contract for deed. If the seller actually owned the property debt-free, you could sell a home to a homeowner with that. And although I have not read the statute per se, I would agree with Sean that at that point you could do it. But the great majority of the time, that's just not going to be an option, I don't think, in Texas, because it's not going to allow you to sell the property to a consumer homeowner utilizing a contract for deed.
Okay.
And forgive me, what was the second point Sean was talking about just a moment ago?
Yeah, so we had a second question. Let me give that one to you. You might like this one. The question was, are there ways to contractually penalize a seller in a sub-2 deal for notifying the lender of the sale? Can you plan for that contractually, and how would you do that? Have you done that or seen that done?
I was just on the phone with an investor this afternoon, not with that exact scenario, but he had bought an interest in a property from an heir. And that heir goes out, he had leased the house out. The heir he bought the house from locked the tenant out of the property, forced the tenant to sign another lease and pay him rent in advance. And of course, this guy had no interest in the property at all. And so he reached out to our litigation counsel to get a cease and desist letter. And I just kind of look and go, good luck. When you deal with these, oftentimes with unsophisticated individuals who really have nothing, unless you have a way to criminally hold them to their feet to the fire and have the police actually enforce something, it's just a waste of time. They don't care. And I think these sellers out here, typically, unless they are carrying back a second lien on the property, some type of a seller carryback note, where there's actually an asset that you can touch and feel, the great odds are you can sue somebody all day long and you can win in court all day. Good luck collecting, and you just threw good money after bad, unfortunately.
Yeah. Yeah, so as a practical matter, you're left with, you know, the difficulty of collecting something. I mean, I guess maybe some scary language in a contract can act to deter somebody from pulling that trigger or doing that, but that's, once the cat's out of the bag, the cat's out
Nah,
of the bag.
but
It's hard to
the
pull
cat's
that
out. I
back.
think that's out.
Um,
Pull that back.
all right. So with that, so that is all of our questions so far. We're going to go ahead. We're at about 47 minutes, about the hour. We've had a lot of good questions. We'll go ahead and call it for the. We still got Scott attempting to come on. We'll go ahead and call it. That's all the questions that we have for the night, and we'll plan on getting together next week. Make sure to bring your questions for all things related to creative finance, and we'll be there to answer them. And with that, we'll see y'all next week, and we'll see you next time, Sean.